So I'd just like to say good evening, everyone who's joined tonight's Employment Rights and Success webinar offered through African Women Australia's Employment and Social Development Program. Before we proceed, I would like to acknowledge the traditional land from which we are hosting the webinar tonight, the land of the Wadawurrung people of the Darug Nation. And I'd also like to acknowledge the traditional lands from which we are all joining in this webinar from tonight. I pay my respects to elders past, present, and emerging, and extend my respects to any Aboriginal and or Torres Strait Islander viewers who will be here with us tonight or viewing in the recording as well. My name is Angelica Ujinaka and I am the Projects Officer at African Women Australia Inc., or AWAU for short. Our mission at African Women Australia Inc. is to raise the voices and profile of African women in Australia. In this evening's webinar, we are joined by our extremely special guests from Migrant Employment Legal Service. The Migrant Employment Legal Service, or MELS for short, is a statewide legal service addressing the exploitation of migrant workers. MELS offers free and confidential legal advice and representation to migrants and temporary visa holders in New South Wales. Our facilitator for tonight is Ida Nursu. I hope I've said that right now. Right, Ida? Yes. Ida Nursu is a solicitor with the Migrant Employment Legal Service and the Inner City Legal Centre in King's Cross, Sydney. Ida has worked with MELS since May this year. Ida has practiced in different areas of law in different community legal centres in New South Wales and ACT. And before becoming a solicitor, Ida completed a PhD in humanities and taught university courses in philosophy, international relations, and sociology. They are joined tonight by Tu Lee, who is the Program Director for Migrant Employment Legal Services. Ida's pronouns are they, them, and Tu's pronouns are she, her. So I'd now like to pass it over to Ida, who will present for this webinar tonight.
Thank you, Angelica, and to African Women Australia for the invitation to present to you today. Before I begin, I too would like to acknowledge the traditional owners of the land on which we're all meeting today. I acknowledge that I'm on the land of the Gadigal people of the Eora Nation, and I pay my respects to their elders past, present, and future. I'd like to also thank Angelica and her team for all the hard work they've put into organising this event and for hosting us. I also want to acknowledge Tu Lee, our MELS Program Director, and the MELS team for all their support with pulling this presentation together, and also to our two practical legal training interns, Nadia Gobe-Names and Katerina Schuler, for their assistance with research. It's especially a privilege for me to present to African Women Australia because I have a personal connection to Africa. I was born in Mauritius, the small island in the Indian Ocean, just off the coast of Madagascar and near South Africa. I'd like to extend a special welcome to all my sisters here today. Now, this presentation will cover some key aspects of your rights at work. We've tried to incorporate some interacting polls. This is my first time presenting over Zoom, so please bear with me, and I hope the technology works for me. If you have a question, please feel free to use the chat box and Angelica will assist in moderating. Now, I just want to say at the outset, the information provided in this presentation is for information purposes only, and it's not to be relied on as legal advice. If you do have a particular situation, you should seek legal advice about your situation, and we'll talk through the presentation about how you can do that. Now, just at the outset, I just want to say and acknowledge that migrant workers experience many barriers in accessing legal help. Some of these barriers or hurdles may be English as a second language. It may be lack of knowledge about the new cultural, political, and social and legal contexts that they find themselves in. It may be hurdles to do with a complex legal system and a completely different legal system from the countries that they originate from. Also, they may be in Australia for only a limited time and may not have, sometimes dealing with legal issues can take time and they may not have the time that they need to do that. Also, getting legal help can be expensive and going through the process can be expensive, and they might not be able to afford that assistance. Also, for some people, it's not something that they would usually do in their cultures of origin or in their community. And to see a lawyer or take legal action may be something that they're not quite used to. They may be concerned that the community would frown upon them for doing so. Also, for others, they have a fear of being fired. They fear that if they raise concerns about their workplace, they might upset their boss and their boss might fire them. And then worse, relating to the last point, it may have implications for their visa. Visa concerns is a significant issue for migrant workers. Temporary visa holders may feel afraid that if they say anything about their work conditions, they might be reported to the Department of Home Affairs. Others fear that if they pursue their legal action, it may jeopardise their hopes of extending their visa or getting permanent residency. So because of many of these hurdles, migrant workers continue to be exploited in employment. Now, I want to acknowledge that it's not easy to stand up for your rights or to go out in a different country and a different culture to access support services. In fact, even attending this presentation today has taken a lot of courage. But I want to encourage you that it is really good if you can talk to a lawyer and to know that lawyers have high standards of confidentiality. It's also important for people to know that they can't be punished for getting legal advice or for exercising their rights to take legal action when their workplace rights have been infringed. So I thought we'd start with a quick poll just to get a sense of how much do you know about your work rights in Australia. So I'll read out the questions, and as I go, you might like to enter what you think is the right answer. Number 1, what do you think is the minimum wage in Australia for a full-time worker? Is it $25, $15, or $19.84? Number 2, does the employer have to give you a payslip? Do you think yes or no? Number 3, can your employer have your visa cancelled because you were sick and did not go into work? Do you think yes or no? Number 4, is your manager allowed to move you to a lower position because you complained about a co-worker making racist comments? Do you think yes or no? And number 5, if you're fired from your job and you think that was unfair, how many days do you have to take legal action? Do you think it's 60 days, 21 days, or 14 days. So once you've locked in your responses, I'll just check in with Angelica if it's possible to share the poll.
Yes, it is. So I've got only a few responses so far, but I can tell you what we've got for some of the answers. So for question 1, we had the top answer was $25 for that question.
Okay.
And for question 2, I think there's still some responses coming through. That's all right. So for question 2, we have yes as the top answer. For question 3, it was even. So 50-50 so far. For question 4, no is the top answer. And question 5, we have 14 days as the top answer.
Okay, thanks everyone for participating. That's very interesting. I'm now going to reveal the answers. Question 1, the minimum wage in Australia for a full-time worker is actually $19.84. Your top answer was $25. Just for further information, for a casual worker, the minimum wage in Australia is $24.80. Number 2, does an employer have to give you a pay slip? Yes, they do. And that was our top answer. Number 3, can your employer have your visa cancelled because you were sick and did not go in to work? It was even. The answer is actually no. And this is a bit of a technical question because, and the reason why I say no is because your employer doesn't have the power to cancel your visa. The Department of Home Affairs does, but your employer does not. Number 4, is your manager allowed to move you to a lower position because you complained about a co-worker making racist comments? Correct. The answer is no, they're not allowed to do that. That would be an adverse action taken against you for raising your workplace rights. And I'll talk more about that during the presentation. Number 5, if you're fired from your job and you think it's unfair, how many days do you have to take legal action? Top answer was 14 days. The correct answer is actually 21 days from the date that the dismissal takes effect. So that's really interesting, and I'm pleased you're here today because we will cover some of these issues a bit further.
Just before you go on, Ida, we do have a question in the chat that is asked from Loza, and it asks, what is the minimum wage for part-time jobs?
That's a really good question, and I had that once before. And look, this is, it's not specified because part-time workers, it depends on their hours, but it would be in proportion to those full-time minimum wage hours. And what part-time workers should do if they have a particular concern is they could contact the Fair Work Ombudsman, and the Fair Work Ombudsman may be able to assist them find out what their award is, which would set out the minimum, or they can also contact MELS to assist them, and MELS can also assist with looking up the award that they're employed under, or help them find out if they are employed under an enterprise agreement, because it will vary depending on their particular circumstance. But there is a way to find out the answer of what they should get paid, and they should get in touch with either Fair Work Ombudsman or MELS. Okay, thank you for the question. So now I just want to tell you a little bit about who we are. Sorry, I'm just going to organise my computer so that it does that. Okay, so MELS, or the Migrant Employment Legal Service, is a partnership between 4 community legal centres, and they are the Inner City Legal Centre, Kingsford Legal Centre, Marrickville Legal Centre and Redfern Legal Centre. And currently we're staffed by a program director, solicitors and volunteers. We aim to address the exploitation of migrant workers in New South Wales. Our purpose is to provide a statewide, free, confidential and independent employment legal service that's dedicated to temporary visa holders and also Australian citizens and permanent residents from culturally and linguistically diverse communities. We can get interpreters if clients speak no or limited English. We can also make adjustments to our service delivery for clients with disability. Our services are confidential, privacy is protected, and when you communicate with a solicitor, your communication is protected by solicitor-client privilege. This means that we don't disclose your details or information to anyone without your consent unless the law requires us to. We also undertake law reform and community engagement, and we provide community legal education. So what issues can we help with? Well, this chart shows some of the areas that we commonly help people with. And these include underpayments or unpaid wages, unfair dismissal and general protections, employee entitlements. So that's things like annual leave, sick leave, carers leave, sham contracts and any contract disputes, discrimination, also bullying and sexual harassment. I'll speak about some of these in more detail during the presentation. Note that we cannot give immigration advice, but we can refer you to other services that may be able to help you with immigration questions. Now, when a person contacts MELS, they'll go through our intake. This usually involves providing some basic details and a summary of the issue that they want advice about. It's also important that they tell us any critical dates and deadlines. Then they'll be booked in for an appointment with one of the MELS lawyers. They'll have a one-on-one advice session with the lawyer. At the moment, this is usually done on the phone. In some cases, we will help with preparing correspondence. This could be, for example, a letter of demand to the employer regarding underpayment of wages. We might help with drafting an unfair dismissal application form in the Fair Work Commission. We might also help with drafting a discrimination complaint to the Anti-Discrimination Board of New South Wales or to the Human Rights Commission. In some cases, we'll assist by representing a client in the relevant court or tribunal. For example, if a person has been dismissed from employment and the matter's been listed for a conciliation, we may represent them at the conciliation in the Fair Work Commission. So, what are your rights at work? Now, in Australia, we have something called the National Employment Standards, and these are the guaranteed minimum entitlements that workers have. And these apply to most, but not all employees. It's a bit technical in the legislation which employees they don't apply to, so I won't get into that now. When you commence employment or when you start a new job, you should be given one of these Fair Work information statements. So you might have seen that before. If you haven't, you can obtain a copy from the Fair Work Ombudsman website. Now, these statements are prepared by the Fair Work Ombudsman, and they set out the national employment standards for full-time, part-time and casual employees. So it covers, so there we go, it sets out the national minimum wage And it also covers annual leave. So for example, full-time workers are entitled to 4 weeks paid leave per year, and part-time employees are entitled to that on a pro rata basis, plus 1 week for eligible shift workers. Casual employees are not entitled to annual leave. It covers personal leave, so that includes sick or carers leave. So full-time and part-time workers, 10 days paid leave per year. Casual workers don't get personal leave. It covers carers leave. Full-time and part-time employees get 2 days unpaid leave per permissible occasion. And casual employees can also get 2 days unpaid leave per permissible occasion. Covers compassionate leave, 2 days leave for full-time and part-time workers, 2 days unpaid leave for casual workers. It covers family and domestic violence leave. That's an important one. We have that in Australia now. And if you are someone who's experiencing domestic violence, you'd be, if you're a full-time worker or a part-time worker, you're entitled to 5 days unpaid leave per year, and casual workers are entitled to 5 days unpaid leave per 12 months. It also covers community service leave. So that's like jury service. So you can get paid, if you're a full-time worker or a part-time worker, you can get 10 days paid leave with make-up pay and unpaid leave as required. And casual employees can get unpaid leave as required. It also covers voluntary emergency management activities. Long service leave is part of the National Employment Standards, and also parental leave. It also covers the maximum hours of work, public holidays, notice of termination, which for full-time and part-time workers can vary between 1 and 5 weeks based on their length of employment and their age, whereas casual employees don't get notice termination. It also covers redundancy pay, okay, and that depends on length of service for full-time and part-time employees, whereas casual workers aren't entitled to that. So I've sped through that a bit, but it's just to give you an idea that there is a minimum set of entitlements in Australian law, and it's a good idea to familiarise yourself with what those are, because those are your basic and fundamental rights. Now, workers are protected, broadly speaking, by 3 areas, okay? And I've already talked about one of them, and that's the National Employment Standards. So that covers the rules for all employers, okay? Then there's the law. The law covers workers' rights. The main one is the Fair Work Act, but we also have other legislation such as health and safety legislation. There's workers' compensation legislation in different states. There's also anti-discrimination legislation. Then there's industry coverage. And what I mean by that is that you may be covered by an award, okay? So an award sets out other minimum conditions like wages, allowances, hours, breaks, shift work, redundancy. And an award is usually specific to a particular industry or occupation. So, for example, if you work in the aged care sector, you might be covered by the Aged Care Award. If you work in the fast food industry, you'd be covered by the Fast Food Industry Award. Awards can be found on the Fair Work Ombudsman website. It's a good idea to know if you're covered by a particular award, and if you are, to familiarise yourself with it. The other form of industry coverage is an enterprise agreement. This is often it's the case that a workplace will have a single enterprise agreement, and this is made between one employer and its employees. What this means is usually the employees bargain with the employers about their workplace conditions. The workplace conditions can't be below the national employment standards, and it can't be below an award. Often trade unions will be involved in the bargaining process. The enterprise agreement sets out specific condition for the employees of that employer only. And you can find that out on the Fair Work Commission website. When you start a job, your employer, it should be in your contract, they should let you know if you're covered by an enterprise agreement, and otherwise you can find out on the Fair Work Commission website if you are. So at this point, I just want to check in with you. Now that we've introduced the broad legal framework that protects workers, I just want to check in with you and have you focus on your specific job. So some things you should think about is ask yourself, what do I actually know about my job? And what we suggest is that there's 3 key areas that is useful for you to be aware of. And these are the areas of classification, pay, and entitlements. Now, classification, I'll spend a little bit of time on. This includes if you're an employee or an independent contractor. So what does that mean? Well, some key distinctions are, if you're an independent contractor, you basically decide what hours you want to work, as long as you complete the specific job you've been asked to do. Whereas an employee, your employer will usually tell you what your hours are. So for an employee, your employer may tell you that your hours are 9 to 5. Whereas if you're an independent contractor, let's say you're a gardener, you may have a job, and so long as you get that job done, you can work whatever hours you want. With an independent contractor, another key identifying point is that you're not entitled to any form of paid leave, whereas as in the national employment standards, I showed you that full-time and part-time employees are entitled to paid leave. Independent contractors usually have an ABN and are paid via invoices for any work completed, whereas employees don't need to provide their employer with an ABN. This is a tricky one, and it gives rise to something that we call sham contracting. And that's something to get further legal advice about, because there can be a blurry line between you may be an employee, but the employer has asked you to provide an ABN, and that may give rise to a sham contract. Now, regarding tax, if you're an independent contractor, you'll usually pay your own tax directly to the Australian Tax Office, and you'll have an ABN, and you'll charge GST, and you usually pay your own superannuation. Whereas for an employee, the employer pays your tax to the Australian Taxation Office, you don't have an ABN, and you're not charging GST, and your employer pays super into your super account. An independent contractor usually uses their own tools and equipment to do their job, whereas an employee uses the tools and equipment of the employer. For example, they'll use the employer's computer and phones, whereas an independent contractor may provide their own. I just want to tell you at this point about a case that went through the Fair Work Commission. It was the case of Amita Gupta and Portia Pacific Proprietary Limited, or also known as Uber Eats. And what happened in this case is that Miss Gupta brought a case for unfair dismissal, and she tried to argue that she was an employee. But what the Fair, and therefore that she was unfairly dismissed. But what the Fair Work Commission found was that she was actually an independent contractor. And they found this because Uber Eats exercised no control over when or how long she performed her work. She didn't exclusively work for Uber Eats. She also was able to accept jobs with other competitors via an app that she used. And she didn't present herself as an Uber Eats worker. Like, she wasn't required to wear an Uber Eats uniform, her car didn't have any logos, and there was no evidence that she was required to even represent that she was part of Uber Eats. So because of that, the Fair Work Commission found that she was an independent contractor, and what that meant was that she didn't come under the unfair dismissal provisions in the Fair Work Act, so she couldn't seek action or compensation for unfair dismissal. So I just thought that was an interesting case to share with you. Okay. Now, with full-time, part-time and casual work, it's important to know what kind of employee you're classified as. If you're full-time, you're usually working 38 hours a week. You're entitled to paid sick leave and annual leave. You're also entitled to notice of termination from your employer. And they need to have a proper reason for ending your employment. If you're a part-time employee, you work a regular number of hours each week. The number of hours will be less than 38 hours. And you're also entitled to paid sick leave and annual leave days. And how much paid sick leave and annual leave you're entitled to will be calculated in proportion to how much you work. You're also, as a part-time worker, entitled to notice of termination of your employment. And that's usually a number of weeks. It'll probably be specified in your contract. And your employment also needs to have a proper reason for ending your employment. With a casual worker, you're employed on an hourly or daily basis, and your working hours can change at short notice, and you're less likely to have a regular work pattern or guaranteed number of hours. You're not entitled to any paid sick leave or annual leave, so that means if you don't work, you don't get paid. However, you'll generally be paid a bit more money per hour than full-time and part-time workers to make up for this. If you're terminated, you're not entitled to any notice of termination as a casual worker. So that means either you or your employer can end your employment at any time without notice or reason. Okay, so you should also know about your pay. You should know about your minimum wage, whether you're entitled to any overtime pay, any penalty rates, shift penalties, and you should have a close look at your pay slips, which we'll do in this presentation. You should also know about your entitlements. So know how many sick days you're entitled to, annual leave, notice of termination, or any redundancy pay. So here's a checklist for starting work. We suggest you keep a copy of your contract and read it well. And if you don't understand it, get some legal advice. A MELS lawyer can help you understand your contract. Know your job category and your pay from the start. So check your award with your boss, or you can also contact Fair Work Ombudsman or MELS to help you with that. Have all the contact details of your boss. So know their ABN or their Australian business number. Why that's important is because you can check on the Australian Securities and Investment Commission website, or ASIC, if your employer is a legitimate business, if they're a registered employer or registered business, or what the status of the business is. You should also know your employer's email and phone details and their name. Keep track of your hours. That's really important. And the Fair Work Ombudsman has an app that can help you do that. You can also keep a diary of all the hours that you've worked. Check all your pay slips and keep them. And write down any conversations about your pay or your job when you have those conversations with the employer. So these are some tips on what you should look for in an employment contract. So an employment contract will usually have details of your position. So it'll state what your position is. In this case, this person is employed as a team assistant. It'll state on what basis you're employed. So whether you're employed on a permanent full-time basis or a part-time basis or casual. Usually you may be subject to probation if you're a full-time or part-time permanent employee, and that'll be provided in the contract. It'll state when your start date is. So this person starts on the 1st of December. And then it'll have your terms of employment. So this is what I was talking about before. This one says that your terms of employment are contained in the Green Company Enterprise Agreement. So that's an enterprise agreement, and that enterprise agreement, hopefully the employer will provide it to the worker, but you should also be able to check it on the Fair Work Commission website. In this case, it says part of the terms of employment is that it's a precondition that of your employment that you have the right to work in Australia and that you can provide evidence of this. So this is when it's important to look at your visa conditions and to see that you have work rights and that they are current. I might just speed through this part. Some other things to look for are the probation period, okay, and how long that is. And how much notice they need to give you if they terminate your employment during the probation period. Your contract should talk about your remuneration. So it should say how much your salary is and what that salary consists of. It should specify what your work hours are and any overtime. It should also outline what your leave provisions are and what you're entitled to. It should say what your duties are. So check what the position description is and what your duties are. And where this is at 3.2, this is an important one. It may state your ordinary place of work. And if you see in this example, it says that your duties at Green Company will be at the Marrickville branch, okay? And it has the address. And then it says in other locations as Green Company may reasonably direct from time to time. It's recommended that you get clarification from your employer on what does that mean? Because I once had a client where the client thought they would be just located in Sydney, but the employer actually wanted them to travel about 2 hours away from Sydney. And that was in the contract, and then that had severe repercussions for that person's employment. So if there's anything ambiguous like that, make sure you get clarity. Okay, there may be a confidentiality provision in your contract, and there may be, there may be provisions about termination, so how much notice the employer gives you, and there may be a restraint of trade clause, and that may be something like you're restrained from working with a competitor for a period after your contract is terminated or you leave the employment. If you're not sure what that means, get some legal advice. We often get questions about that. Okay, so consider this for a moment. 9 out of 10 migrant workers suffer wage theft in silence. Now, that's a very frightening statistics. When we refer to temporary migrant workers, we mean people who are in Australia on a temporary visa. They could be on student visas, temporary work visas, working holiday visas, temporary skill shortage visas, skilled or temporary graduate visas, provisional partner visas, temporary protection visas, bridging visas. And wage theft can be in the form of not being paid the correct amount for your age, being paid less than the award, being paid as a casual and not being entitled to paid leave when you're really a part-time employee, not getting paid according to your award or enterprise agreement or your contract, and being paid as an independent contractor when you're really an employee. That's what I meant by sham contracting earlier. So many people, temporary migrants, suffer in silence. They're often too afraid to say anything because they're afraid that they'll lose their job or their visa, and they feel alone and they feel isolated. This is why it's important to get legal advice, because this is a very high statistic. And a lawyer can help you to understand your contract, your award, your enterprise agreement, and to do the calculations to help you figure out if you have been underpaid. They can help you to negotiate with your employer for the payment that you should receive. And they may also assist you by writing a letter to your employer or to make a complaint with the Fair Work Ombudsman, or should the matter require going to court, they may be able to help you take the matter to court to recover your money. So this is an example of a pay slip, and a useful way to check that you're receiving the correct payment is to check your pay slip. So here, check your employer's name, okay? Check their ABN number, their Australian business number. Check that your name is correct. Check the date of payment, that should be here in the pay slip, and the pay period. Check the gross, net, and the net pay. So you've got that down here. Check any loadings and allowances. For example, this person gets a laundry allowance, and check that that's all correct. And check if you get an hourly rate, check what that hourly rate is and that it's correct according to your award or enterprise agreement or contract. Check that your bank account details are right as well. If you're paid a salary, the rate, check that it's the rate as at the last day in the pay period. Any deductions from your salary you should check. So check the tax. Here there's a superannuation contribution. So check that that's correct and that it's going into the right super account. So pay slips should be issued to employees within 1 working day that you're paid. And if you've been underpaid, you can contact MELS for advice, and the Fair Work Ombudsman can also help you. You can go to fairwork.gov.au for that. Okay, so flexible work is an issue that's particularly significant for women. In Australia, an employee can request a flexible working arrangement if you've been with your employer for at least 12 months and if the following applies. If you're a parent or you have responsibility for the care of a child who's school age or younger, if you're a carer, if you have a disability, if you're age 55 or older, or if you're experiencing or supporting a family or household member who is experiencing violence from a family member. The most common requests about changes to work that are made are to, for example, ask if you can start work earlier in the day or finish later in the day, for example, to fit in picking up children from school, or changes to where you work. So for example, a request to work a few days from home, or changes to your pattern of work. So for example, splitting your shifts or job sharing. So how do you ask an employer? It can be, you know, a bit of an uncomfortable topic to raise, but the best way to do it is to ask your employer by giving them a written request and to keep a copy of that request. You should include the details of what you're asking for and the reasons why you're asking for it. And your employer needs to reply in writing within 21 days. The employer is allowed to say no to your request, but only if they have good reasons known as reasonable business grounds. Okay, now we come to a topic that I understand a lot of participants were interested in, and this is on discrimination. So I'm wondering, Angelica, if we could do another poll.
Yep, I've just launched the poll for you now.
Thanks very much. So the first question is, have you experienced discrimination in a job interview? Yes or no? Second one is, have you experienced discrimination in a job? Yes or no? And then the third one, and you could, if you would like to share your experience, you can indicate yes, and then maybe write some comments in the chat box, but de-identify. So don't give details about yourself or the employer, just generally the kinds of things that happen, because we want to protect people's privacy and confidentiality in this presentation, especially as it's being recorded. So I'll give you a minute or two, Angelica.
Yeah, sure thing. We've had one person indicate yes to sharing their experiences. So we'll just wait for them to put those into the chat for you.
Thank you very much for volunteering.
Just while we're waiting, just to share some of the results. So for question one, we had majority say yes for question one, which is very sad to definitely hear that that's the experience that people have had in the interview process. With question number two, it was 50-50. So half yes, half no to experiencing discrimination in a job. And we've also got another person who wants to share as well their experiences. So if you would like to share your experiences, just put it in the put them into the chat, or you can put them in the question and answer section so you can send it anonymously as well. Okay, so we've had someone anonymously send on the Q&A section just now that I was discriminated against when I asked for some time off for an event that happened overseas. I lost a family member due to violence in my home country, but my workplace was not responsive. So I'm assuming that maybe responsive means that they were not as accepting to giving time off. If you'd like to add more to your experiences, feel free to. If not, that's totally okay.
I'm very sorry to hear that happened to you. And I think we have another one, Angelica.
I believe so, but I'm just not sure who exactly that is from. I just saw another yes tick on the poll. So
Okay.
if you do still want to share your experiences, feel free to in the chat or the Q&A section where you can put you can tick send anonymously so it doesn't send your name. Otherwise, if you don't feel comfortable to, that's okay. We can proceed.
Yeah. I've just seen in the Q&A, there's another one where the participant, can you see that one, Angelica?
Is this the question from Ellen?
Yes.
Yes. This question was asked previously.
Oh, sorry. Okay.
We have two questions actually that were asked previously, but if you'd like to answer them now, that's okay, but we can also save them to the end Q&A.
Yeah. The second one is I can't give you legal advice about your specific situation, but I see that what you've raised is discrimination about going through selection processes, making it to the final interview and then being told that you're not successful because there was an Australian citizen. So it sounds like you felt that you were discriminated because of your immigration status. So I can't give you advice specifically, but I will talk about discrimination generally. And then I see there was another question. Should I visit MELS or a migration agent or migration lawyer to talk about work conditions? Yeah, that's a good point, because as I said before, we don't give immigration advice at MELS, but it depends what work conditions you're talking about. If it's some of the things that I've raised in this presentation, like about your entitlements, your pay, how your employer is treating you, then those are things that MELS can help you with. If it is about your specific visa requirements and obligations or your employer's responsibilities, if it's a work visa, then that's something an immigration lawyer or migration agent can talk to you about. You can contact MELS if you're not sure, and we can help you work out what would be the best pathway for you. So thanks for those questions. So a majority have said that they've experienced discrimination in a job interview, and about 50-50 of our participants have experienced discrimination in a job. So that's quite a high statistic from our participants. So what is discrimination? So here's the thing. In the law, discrimination has a very specific meaning. And sometimes what people may feel is discrimination may very well be discrimination and be upsetting and feel, you feel degraded or ostracized or disrespected, but it may not meet the legal definition under the law. And if it doesn't meet the legal definition, it doesn't discount your experience. It's just that the law is a specific construct. So in Australia, all workers, even people who are applying for a job, are protected from discrimination in the workplace. And unlawful discrimination occurs when your employer takes action against you because of your or your family members. And these are what we call attributes. And these attributes are sex, including pregnancy and breastfeeding, sexual orientation or gender status or intersex status, race, including colour, physical or mental disability, age, relationship status, family or carers' responsibilities, religion, or political opinion. So those are all specific grounds or attributes that you can be discriminated for. Now, there's two kinds of discrimination. And the first kind is direct discrimination. So this is obvious unfair treatment. This is, for example, if you're told you're too old to apply for a job, okay? It's obvious. Or if explicitly racist remarks are made at you. Then there's indirect discrimination. And this is a less obvious form of discrimination. This is, for example, if a workplace has a requirement or a rule which seems to be the same for everyone, but it actually has the effect of disadvantaging you because you have a protected attribute. So, for example, if a workplace has a blanket policy that all workers, all employees must work full-time, that may look like it's treating everyone equally. But then when we look a bit deeper, it's actually disadvantaging women or parents who have family responsibilities because they may not be able to work full-time. They may only be able to work part-time because they need to care for children part-time. So that's an example of indirect discrimination. So discrimination can be quite a difficult area to work out what is or is not exactly discrimination under the law, and that's why it's useful to get legal advice about it. Now, the kind of action that your employer is not allowed to take because of a protected attribute is they're not allowed to end your employment or refuse to employ you in the first place. They're not allowed to harm you in your employment, so in any way, including by dismissing you or financially by paying you less. They're not allowed to change your position and leave you worse off, or they're not allowed to treat you worse than your co-workers. So what can you do if you've been discriminated against? Well, you can contact MELS for advice. You can speak to your employer. So if you believe your employer is discriminated against you, you can talk to the supervisor, manager, or the boss. That can be a good place to start. But I understand many people would feel uncomfortable about that. In theory, they should listen to your concerns and they might be able to suggest a solution that works for both of you. You can also approach the Australian Human Rights Commission. They actually investigate and try to resolve complaints about discrimination, and they do that free of charge. You can call them on this number, 1300 656 419, or you can file a complaint by visiting their website. Importantly, you have 6 months to make a discrimination complaint to the Human Rights Commission. If you're in New South Wales, you can also seek help from the New South Wales Anti-Discrimination Board, and they also provide information and try to resolve complaints through conciliation, and they do that free of charge. And you can phone them on 1800 670 812 or file a complaint by visiting their website. The difference there is that there is a 12-month limitation date for making a complaint in New South Wales. Understand that we have participants from other states, and you should check in your state what the provisions are with your particular discrimination board. Another option is to file a general protections application in the Fair Work Commission, or you can seek help from the Fair Work Ombudsman. In some cases, they can investigate allegations of unlawful workplace discrimination. Now, I just want to mention a case study. It's a bit of an old case, but it's a reported case that was in the Human Rights and Equal Opportunities Commission, which is now the Australian Human Rights Commission. And this was Mr. Rugama. I apologise if I'm mispronouncing his name, but he was a former political refugee from Uganda. And he complained of continued and prolonged racial abuse at work over a period of 6 years. And this abuse was predominantly by a senior colleague who was found to have called him several racist names, as well as having made monkey gestures. Now, this abuse was found to have resulted in him suffering a major depressive episode with various post-traumatic stress symptoms. So workplace discrimination can be a risk to your health and safety. Now, he made a complaint, and then this was heard, and it was held that this abuse constituted a breach of the general prohibition against racial discrimination contained in Section 9(1) of the Race Discrimination Act, and it was a prohibition against racial vilification that's contained in Section 18C of the Race Discrimination Act. And it was also found to have breached Section 15(1) on the prohibition on discrimination in employment. And he was awarded damages of $55,000. So that's a matter that's progressed quite far. A lot of cases in this discrimination area may be settled at conciliation, and a lot of them, because it's confidential settlement, if it's settled, will be not reported. So just to give you a little bit of the law, sorry, just having some problems here with my computer. Okay, so basically the sections that were referred to is Section 9(1). So it's unlawful for a person to do any act involving distinction, exclusion, restriction, or preference based on race, colour, descent, or national or ethnic origin, okay? Which has the effect of nullifying, so voiding or impairing the recognition or enjoyment or exercise on an equal footing of any human right or fundamental freedom in the political, economic, social, cultural, or any other field of public life. So that's quite broad, but that's our broad prohibition on race discrimination, also including colour, national, ethnic origin, okay? And what you might get a sense of is that it does incorporate our obligations under international human rights law. Section 18C is offensive behaviour because of race, colour, or national or ethnic origin. So there has to be a link there between the offensive behaviour and race, colour, ethnic origin. And here's an important component of that it's unlawful for a person to do an act otherwise than in private. So what that's referring to is that it's in a public place. So this can include a public place like a workplace, okay? And that offensive behaviour is behaviour or an act that's reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate another person or group of people. So those are the elements, that it has to be offensive, it has to insult you, humiliate or intimidate you, and the act is done because of race, colour, national or ethnic origin. And Section 15(1) is basically putting it in the context of employment. So that may seem a bit complicated, but those are the different elements or the legal components that goes to a race discrimination action in employment. So that's why it's helpful to talk to a lawyer, because what the lawyer will do is you'll describe your situation and then the lawyer will apply the law to help you understand if it's one that would be covered by Australian discrimination laws. Okay, and then, sorry, Angelica, I'm aware that we're running to time. So I'm wondering how much time do I have left of the presentation?
So I would say that you have about 5 minutes or so left of the presentation, then we can go to questions. We've only got one extra question that's come through on top of the ones you've already answered. And just in case there's any more, we'll just save a bit of time for that.
Okay, thanks so much. So I might talk about bullying and harassment because that's one that I understand is of interest to our participants today. So what's bullying? Well, bullying happens when a person repeatedly acts in a way towards you that creates a risk to health and safety without a proper reason for doing so. And the behaviour that's not allowed includes insulting you, humiliating you, threatening or intimidating you. So some common examples of bullying are teasing you or making jokes about you, playing pranks on you, excluding you from workplace events, swearing or yelling or otherwise being abusive, making you do unreasonable things for work, such as a lot of work in an impossible time frame. That could be bullying. It's important to understand that a one-off incident is not bullying. It has to be repeated behaviour. And an important thing to distinguish is what people may think is bullying from what's proper performance management. Proper performance management is not bullying. Even though it may make you feel upset, your managers are allowed and expected to review the quality of your work and give you feedback. If you're not sure, that's why it's also good to have a chat to a lawyer about it. Harassment is, well, all employees in Australia have the right to be protected from harassment at work. In New South Wales specifically, there's law that says you can't be harassed on the basis of your sex or disability, and it can be behaviour that's targeted towards your sex or disability or behaviour of a sexual nature that makes you feel offended, humiliated or intimidated. So those are the key elements: offended, humiliated or intimidated. Unlike bullying, harassment can be a one-off incident. So it can be like telling rude jokes such as sexist jokes, can be sending you explicit or sexually suggestive messages, sharing offensive images like pornography, or saying insulting things about sex or disability. So what can you do if you've been bullied or harassed? You can contact MELS for advice. You can speak to your employer if you believe you've been bullied or harassed in your workplace. You can speak to the supervisor, manager, or boss, and they should listen to your concerns and find a way to stop the bullying or harassment. But again, I appreciate that may be very hard for people to do. You can seek help from the Fair Work Commission. Fair Work Commission can try to resolve bullying complaints between you and the employer, or if there's an issue in the workplace, and they can make stop bullying orders. So, and there's an application on their website, or you can get further legal advice about that. As I said, bullying can be a risk to your health and safety. So you can get further information if you're in New South Wales from Safe Work New South Wales, and they may investigate your complaint. You can also, for harassment, approach the Human Rights Commission, and they can investigate your complaint and try to resolve it, and that would be free of charge. Now, I'll just skip ahead just to talk about unfair dismissal, because that's one that commonly comes up. And basically, unfair dismissal occurs if you're dismissed from employment and the dismissal was harsh, unjust or unreasonable, and it was not a case of genuine redundancy, and where the employee was employed by a small business if it was not consistent with the small business fair dismissal code. What that means is a small business has fewer than 15 employees, and the small business fair dismissal code is the specific code that those employers have to abide by. And in considering if dismissal was harsh, unjust, or unreasonable, the Fair Work Commission would take into account whether there was a valid reason for the dismissal that related to capacity, to the employee's capacity or conduct, if the employee was notified of that reason, if the employee was given an opportunity to respond to any reasons relating to their capacity or conduct, if there was any unreasonable refusal by the employer to allow the employee to have a support person present at any discussions relating to their dismissal, and if the dismissal related to unsatisfactory performance by the employee, whether or not the employee had been warned about that unsatisfactory performance before the dismissal. They'd also take into consideration the size of the employer's enterprise and how that would impact on the procedures that were followed by the employer in dismissing the employee. And they'd look at the degree to which there was any human resources personnel involved or expertise, and any other matters that come up. So where an employee wants to file an unfair dismissal application in the Fair Work Commission, it's important to note that they have 21 days from the date the dismissal took effect. And that was one of our poll questions at the start. So again, if you've been dismissed, it's important to get legal advice straight away. Another thing that comes up is that people may feel that they were forced to resign, and that may border on the area of unfair dismissal. It may be what we call a constructive dismissal. So just to conclude, basically some key rights that you should be aware of is that you have the right to be paid correctly and on time with pay slips. You have the right to be safe at work, to be free from bullying and harassment. That is not to be discriminated against because of your age, your sex, your gender, your religion, your disability, your sexual orientation, your race, your skin colour, your national origin, and more. You also have the right to seek assistance if you need it. So you can go to the Fair Work Ombudsman or the Migrant Employment Legal Service, and you can't be punished for getting legal advice. And you also have the right to remain in employment even if you raised a workplace right, like a question about your payslip or if you took a sick day. So for further advice, you can contact MELS, and these are our contact points. So you can call us on 02 8002 1203. Again, our services are for New South Wales residents. We're also, we've also got a website and a web form, or you can email us. Okay, sorry, I've talked for quite a bit and we'll open it up for questions.
Thank you so much, Ida. That was, even for myself, I learned quite a lot from that, and all the things that you shared. To receive this type of information and so extensively, we're really grateful for you and all the work that Migrant Employment Legal Service does for women and African women and all women of migrant backgrounds as well. So we do have two questions that have come through, three actually, and so we probably will have time to answer these, and if there's any other questions that anyone has, feel free to, we'll provide contact details to you for MELS, as well as African Women Australia can also refer you on to MELS as well. So the first question that we have here is, during the height of the COVID pandemic, many international students became victims of job layoff. Does this fall within discrimination? And what specific action were these students supposed to have taken?
Okay, that's a really good question. Look, it's going to depend on the particular circumstances. And this is the thing with discrimination law. It's not just blanket, this is discrimination. It's really going to affect on the particular circumstances of that case and whether the reasons were because whether it was direct or indirect discrimination, particularly to do with your race or your national or ethnic origin. So it's going to depend on the circumstances on how the employer laid off the particular workers and whether they were the only ones and whether, and it's really difficult with COVID because, and I find COVID has really challenged our employment laws. And because with COVID, there were, for example, there's an issue whether employers lawfully stood down workers or if they sacked workers, there's a question about, well, does it amount to an unfair dismissal? So it's really going to depend on your specific circumstances. So I'm sorry, I can't give you a general answer to that. But if you do have a specific question about your situation, get in touch with us because a lawyer would be very keen to talk to you to find out exactly what went on.
Okay, great. Thank you so much. The next question that we have is, to survive, many student migrants take up jobs even without proper documentations, as you have specified, and for fear of losing jobs have to deal with many issues, including firing via text messages. When proper formalities have not been followed, does the law still protect us, especially as migrants?
Yes, and this is what I was getting at in the presentation, that statistic, 9 out of 10 temporary migrant workers experience wage theft or have other conditions like being fired. And yes, we see that in our practice as well, that employees aren't given proper documentation and sometimes they're asked to pay for things when they shouldn't be. So yes, the law, there is protection under the law. With the firing via text messages, look, that may give rise to an unfair dismissal. Again, it's advisable that you get legal advice. So yes, I want to say that you do have protections and get in touch with us if you're in that situation. And I know that for a lot of international students, they're concerned if they may have worked more than the hours that they're allowed to. Just know that when you speak to a solicitor, everything that you say is confidential, okay, and protected by solicitor-client privilege. Unless if the law requires us to report, but the solicitor will let you know if that comes up, okay?
Great, thank you so much. And we do have one final question. What if my workplace doesn't believe that I was either offended or humiliated from what I describe? And I believe that might be in connection to harassment. Are MELS able to help me distinguish this and provide support as to how I can move forward?
Yes, thank you very much for your question. This is something we hear about often and often can be a deterrence for people coming forward and reporting harassment in the workplace. And I understand people's concerns for doing that because yes, many workplaces may not believe the person or the workplace may be afraid of an issue. They may be afraid of having legal action taken against them. So they might not deal with it appropriately. This is why if you're not sure if you should go to the employer or to your boss or supervisor, do contact MELS because then we can speak with you about what the conduct was, what you experienced, and we can apply the law and, as you ask, help you distinguish whether it was harassment or was it bullying. And we can provide support. For example, we can give you options on what to do. Or if it's a matter that you could make a complaint about to the Human Rights Commission or Anti-Discrimination Board, MELS can advise you on how to do that and also help you put your application together. So the answer to that is yes, we can help you with that kind of inquiry.
Thank you so much, Ida. And we are out of time, but I do want to just thank you and too as well for all your support that again that you give migrants, and we hope that this webinar is really valuable to African women and those who attended and those who may be listening to this once the recording is up, but we do really appreciate and value your time, so thank you so much.
And thank you, Angelica, and to your team. And thank you also to all our participants who asked questions and shared their experiences with us. It was very brave of you to come forward. And please contact us, and I wish you every success in your future employment.
Thank you very much. Did you want to say anything quickly?
Yes, just in the last minute. Thank you so much, Ida, and to Angelica and the team for this opportunity to share our service with you. And if there's anything, I know there's a lot of information in there. If there's anything that you do take away is don't hesitate to contact MELS if you're unsure, if you have a workplace problem and you think you may have a claim, contact us and get that advice. The most important thing is that you do understand what your workplace rights are, and hopefully after today you have a bit more knowledge and understanding of what your rights are and who you can contact. So MELS, if you do have an issue in your employment and you'd like to seek some free and confidential legal assistance.
Amazing. Thank you so much. Well, that concludes the presentation. Thank you everyone who's attended, and we'll be in touch with the survey regarding the webinar, as well as all resources from MELS as well. So thank you.
Great. Thanks,
Thank
everybody.
you. Okay. Goodbye. Good night.
Good night.